I'm going to click on this little I button here to see how many people we have, but it isn't telling me, even though Mikey told me it would. Okay, I'm going to presume that we are going live. My name is Dan Hershkowitz, and I'm thrilled to be here today with Vicki Nadorf. She does not require an introduction, but I'm going to give her one anyway. She is certainly one of my mentors and good friends and colleagues in the real estate field and in real estate risk management and law. I have known Vicki for at least 10 years. When I started to know her, she was general counsel for Coldwell Banker. Many of you have heard of them.
Brokerage counsel. I wasn't their general counsel. I specialized.
In fact, that's even better, brokerage counsel. Thank you very much. And so her job at Coldwell Banker was to set standards and to teach and train the agents and keep them from getting in trouble. In fact, that's what I try to do in Northern California at Compass, where I am the Director of Risk Management under the tutelage of Kathy Maringer. And many of you know Kathy as well. I mention her because she is also a Coldwell Banker woman and another wonderful mentor in this field. Vicki and she worked together for, 20 years probably, all in all. And Vicki continues to keep us on the straight and narrow. With her partner in crime, Bill Jansen, they are together broker risk management, and that law practice is the two of them consulting, 6,000 realtors up and down California?
At last count, it's getting closer to 9,000 at this point.
All right, and she is keeping them and you on the straight and narrow. And so today we are happy to be here together to talk about discrimination and fair housing, and we will be tag teaming. And hopefully, within this 40 or 50 minutes, however long we have, you will learn a lot. Vicki, get us started.
Well, many of you probably are wondering why we are conducting a seminar on discrimination and fair housing. This is not exactly a new topic. And as real estate professionals, you are committed to equal housing opportunity. However, for today, what we're going to be looking at is how the fair housing laws have actually evolved. And while Dan and I are going through this material, I want you to start asking yourself, is it enough to just have state and federal fair housing laws? Is there something more that realtors should be considering doing so as to correct the evils in the past? We're going to review the current actions being taken by organized real estate, as well as some of the changes that may be necessary in advertising. The brief history of federal law on the subject of fair housing is really summarized by 4 points. You have the United States Constitution, which says people are to be treated equally. Equal treatment in housing is part of that constitutional guarantee. However, the first federal fair housing legislation, which was known as Title III, was not put into law until 1968. At that point, it was very narrowly drawn, and there were only 4 protected classes. 20 years later, in 1988, there were 7 protected classes. Then, in 1990, the Americans with Disabilities Act was passed by Congress. It guarantees equal access and necessitates reasonable accommodations for people with disabilities, both in the realm of housing and employment. This slide is a brief summary of the specific acts under federal law which are deemed to be discriminatory. All of these are important, but the 3 that have been probably the big 3 issues for real estate professionals over the years has been blockbusting, which is where a real estate professional goes into an area and tries to scare people into thinking that their neighborhood is going to change so that they leave and new people can come in. Redlining, a practice by which lenders would designate which areas they were and were not willing to lend in. And then finally, the most frequent problem for real estate professionals has been steering. So what exactly is steering? It's the practice of using words or actions to influence the choice of which neighborhoods to live in by either a prospective buyer or tenant. The end result is residential segregation. Over the years, there have been two broad categories of steering. The first is advising buyers and tenants to choose homes in a particular neighborhood solely on the basis of the person's race or other protected status, as perceived by the realtor and not as requested by the buyer or tenant. For example, telling people with an Asian background that they are supposed to only live in areas where other Asians congregate. The other broad category of steering is failing on the basis of the person's race or other protected status to show or to inform buyers or tenants of residences that meet their their specifications in other areas. I mean, San Francisco is 7 miles by 7 miles. There's lots of areas, but it is not unheard of that at times real estate professionals, for whatever reason, will choose which parts of San Francisco that buyers or tenants are to see.
Can I interject here for a minute?
Absolutely, Dan. Besides, I can't stop you.
All right, perfect. So some of you saw the amazing documentary that was done on steering in the Long Island, and it was, oh gosh, I forgot the New York Post. Forgot who it was. But if you search Long Island realtor steering, my God, you will find this 45-minute documentary that is amazing. And
it was based on a 3-year study in which real estate professionals with many different real estate brokerages were tested. They would have an all-black couple go in and put forth a specific set of wants, needs, and financial information. Then they would send in a white couple with the same information and either an Asian or Hispanic couple. And they would test this information with various real estate professionals, and all of those groups saw completely different properties.
And
it was shocking.
The numbers are really something, and they took real care. So they gave everyone the same speeches. They were all basically out-of-work actors. The women were even all given the same purses, right? So, and they were all dressed the same. They did it all the same, and it was the same information. And 50% of the African Americans were discriminated against in terms of steering. So they were sent to neighborhoods and to properties that the white people were not, or they were not offered the same neighborhoods and properties that the white people were, otherwise exactly the same. And it made me really think and look back at my time as a realtor in San Francisco. And one of the interesting discussions is, what neighborhoods do you suggest, Dan? Right? And this is an interesting question, and a question of both intentional and unintentional bias, right? What schools are good, Dan, is often a code word for these same conversations. And so one thing I would definitely want you to take from this conversation is using objective criteria. So, and setting up standards that apply to everyone. So if you're going to take someone's license before you go touring, you're going to take everyone's driver's license before you go touring. If you are going to, for instance, give recommendations regarding neighborhoods, you're giving the same recommendations to everyone, which is, here's my neighborhood descriptor. And it was produced by the local association of realtors, and it explains all the neighborhoods for you. And here are the marketing data regarding them, and here are the comps regarding them, the median sales price, et cetera, et cetera. Where do you want to focus? I'm happy to take you there, right?
And that's really the important issue, is where does the prospective client want to look? The most important takeaway on the concept of steering is that when it comes to fair housing cases, even if you thought you were acting in the client's best interests, even if you thought you were doing right by them, which is a term that I've heard many agents use when they are facing a claim at the Department of Fair Employment and Housing, is that what you intended isn't important. It's the effect of your words and actions on the recipient, which is why you must be consistent in your treatment of everybody. Now, one of the things that we point out here is that, yes, the buyers, the tenants, they can be discriminatory. They can say, Dan, I don't care which neighborhoods you think are the best. or I don't care which school you think is the best. I only want to see homes where my kid will go to a particular school. If that's what the clients are telling you, then you want to document, for example, in an email, that you are specifically limiting your search based upon the specific requests or parameters of the buyers or tenants. But if you are the one who's directing those same home buyers or tenants to specific areas based solely upon your own preconceived ideas of what someone in a protected class would want, then you are acting in a discriminatory manner and violating the law. It's important to understand the significant problems that real estate professionals face if they are accused of housing discrimination. There are a number of very costly remedies available to victims of housing discrimination. That's why every one of them on this list has a big red $sign. I can tell you that although punitive damages are at times imposed, the majority of dollars in these kinds of cases is spent on emotional distress damages and attorney's fees. And quite frankly, you could add up all of those other $signs and they would just barely equal the attorney's fees in these kinds of cases. The bigger problem for real estate professionals, E&O does not cover fair housing claims.
And your E&O is your malpractice insurance, which is...
And it is critical that you understand that these big ticket items are going to be coming out of your own pocket. One other negative factor to keep in mind is if you have been found guilty of violating either state or federal fair housing laws, DRE can revoke your license. Today's NAR Code of Ethics in Article 10 makes it clear that as real estate professionals, you cannot discriminate when you provide services to anyone. You cannot discriminate on the basis of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. These are the classifications on the federal level. What you may not know is that the Professional Standards Committee recently made recommendations to the NAR Board of Directors, and in November of this year, there may be some significant revisions to Article 10. Those revisions are going to primarily focus on something that NAR has been dealing with for the last 7 or 8 months. It's the subject of hate speech. And please be aware that if Article 10.5 gets passed, and it looks like it may well do that, then real estate professionals who express hate speech or negative views about anyone based upon their race, color, religion, etc., will be subject to an ethical complaint, and the penalties are going to be rather severe, and they will increase depending upon the number of times someone has violated the ethics code. NAR has already stepped in and has made specific recommendations with respect to how real estate professionals should be advertising property. NAR is already recommending that you should not use certain phrases, especially those that start with the word "it's perfect for." And I know when you see this list, don't say to yourself, "Oops, I've already used that." Instead, remind yourself not to say that it is perfect for empty nesters, that it is perfect for single individuals or families with small children, or perfect for married couples. When you use those phrases, you are showing a preference for the type of buyer or the type of tenant. NAR also recommends avoiding phrases that describe a neighborhood as being kid-friendly, primarily Hispanic, exclusive, private, or integrated. From NAR's perspective, this is showing bias. And showing a bias is discrimination.
Can I jump in for just 1 minute?
Sure.
So I was reminded of two things. One was earlier you said that the tenant, for instance, could show their own preference. And what I want to make sure people understand is we were having a discussion about neighborhoods and steering. And steering is an issue of not only an intent or not an intent, but a disparate impact. That's different from a client who says to you, I don't wish to sell to, and then is describing any of these protected classes, 22 in the federal side, plus several in California. That's a different story. Just because your client is trying to break the law doesn't mean that you have to go along with them. In fact, you cannot go along with them, and you must make an affirmative stand. So,
and I'll get to that shortly.
Okay, good. And I'm just going to give one, for instance, if I might. So the client who says, I only want to live in the Castro, completely up to the client, as opposed to the client who says what they think is innocuously, listen, for my neighbors who are good people and older people, do us a favor, don't show the condo to any families with little kids. I promised Sarah upstairs that we would try to keep it only to singles to make her life easier. Okay?
And we have some examples there as well.
Great. I will be quiet.
Good. I think that one of the problems for many real estate professionals is they go to a class, they learn some do's and don'ts, and then they stick with it. Not too long ago, I was in a symposium on the subject of fair housing, and an expert in the field said that it's okay to say that a property is located within a short walking distance of something else. That term is getting reevaluated, and quite frankly, I think it's about time. Maybe we should be more sensitive to using terms such as family room, master bedroom suite, plantation shutters. Remember, there are buzzwords that can set somebody else off. No, you're not trying to intimidate or discriminate when you use those words. That's not the important issue. It's how the person who hears the information is receptive to it. So keep in mind, words that have been acceptable in the past may now be unusable. So I can't stress that issue enough. One
interesting thing, Vicki, we'll find in a few months is that the words that are used by the MLS to describe the various bedrooms, there's a standard, and I forgot what they call the name of the standard. Nina will know, she's on here. RESO, thank you very much. Real estate standard something. And the idea is that all of our fields should be the same so that we can share data. And so if we call something a townhouse, but somebody else calls it something else, real estate standards organization, it makes it very hard to share data. RESO has decided that when they make their changes the next time, primary bedroom will be the term used instead of master bedroom.
One thing to keep in mind, real estate brokers have one regulation which controls their supervision of real estate professionals that affiliate with the brokerage. One of the key elements of broker supervision is the obligation to familiarize salespersons with the requirements of federal state laws relating to the prohibition of discrimination. So even the DRE has an interest in making sure that the fair housing laws are being followed. Dan mentioned 22, the number 22 just a moment or two ago. That's not on the federal level. There are now 22 bases in California because on January 20th, 2020, the Department of Fair Employment and Housing, DFEH, issued new regulations that went into effect the day they announced them. If you are an insomniac and you really want to read the regs, feel free. That is the website. But there are some basic concepts in the new regs which are important for us today. Discrimination means showing a bias against. That everybody knows. Here's the one that people miss. A preference for anyone who falls within one or more protected bases. These are the 22 housing protected bases under the DFEH regulations that went into effect this year. Some of these are also based upon new laws in California, such as you cannot use source of income, including Section 8 and other government voucher programs, as a basis to rent property. The one that causes the most laughter is the genetic information. Keep in mind, DFEH deals with employment as well as housing, and genetic information has been used to discriminate in the housing arena, which is why on the federal level, there's an act called the Genetic Information Non-Discrimination Act, or GINA. This was passed because some major employers and their insurance companies who were providing health benefits were choosing employees as to whether or not they did or didn't have certain genetic predispositions to diseases such as sickle cell anemia. The liability for discriminatory housing practices can be direct or it can be vicarious. And the important factor to keep in mind here is that you can't stand by silently and watch a third party, such as your own client, who you have the power to correct their bad acts. You can't just stand there and let them discriminate. You have to take action. The bottom line in the new laws is that failure to take prompt action to correct and end a discriminatory housing practice can create liability for a real estate professional. And if you can't correct it, if you know the client is going to discriminate, the only solution you have is to walk away. Now, here are the examples that Dan was alluding to earlier. But what if my client only wants to sell or rent to people who are Irish? They're not against anybody, they just like Irish people. Or they really only want to sell to people who will appreciate the fact that there are 4 Orthodox temples nearby. Or, gee, we've enjoyed raising our children here, so we only want to rent to a family with kids. Or we only want someone who reflects the same moral fiber as the seller or landlord. Guess what? That's buzzword talk for we only want to sell to people who look like us. If that is what your client is expressing, your client is intending to discriminate. If you cannot get them to stop, you need to walk away. Unfortunately, over the years, it's been difficult for many real estate professionals to really tell their clients, no, you can't do that. So a system of cues, verbal cues, have come into existence, which we now know you cannot use, because you cannot agree either affirmatively or impliedly to screen out buyers or tenants based on their status. Yes, you can tell people you can't do the screening, but you also have to tell them that they aren't free to make those same discriminatory acts. You cannot stand by and be silent. Those days are gone. If you cannot stop the seller or landlord from pursuing any type of discriminatory practice as both a matter of law and as a matter of ethics, you must walk away. So, Dan, in a couple of these slides, we've talked about the fact that there's the Americans with Disabilities Act, but what exactly is considered a disability under California law?
Well, so by the way, I think that should be your avatar, that the scales of justice in that particular one. I love that. Okay. So
happy you like my work.
So a disability, as we say here, is anything that limits a major life activity, and that could be mental or physical impairment. And what is a major life activity? Well, I'll give you some for instances. Your ability to work, your ability to communicate, your ability to access housing, your ability to access transportation or transport yourself. So when we have a life activity included, we have to think about physical, mental, or social activities and working. These are all major life activities. Okay. What's interesting is that there's also a secondary definition, which is a record of having or being perceived as having a mental or physical disability. So even if you don't, so to speak, have one, but the world perceives you as having one and discriminates against you on that basis, you are being discriminated against. You have a disability under California law. A disability can be permanent or it can be temporary. Let's go into the next slide, which you're going to love. So everybody loves to talk about assistance animals, right? They say, okay, that's emotional support animal. That's a service animal. That seems to be different. Well, let us help you with this. On this slide, you'll see a 1 and a 2, and it breaks them down into service animals and support animals. Both of them are assistance animals. And here's the thing that you need to understand. And this is the thing, and here's going to be my little quick reference for you, which I think will be helpful. And Vicki, I'm curious to see how you think of this. If someone said to you, I am working for Jill and Jack Corporation, and my doctor has presented me with a note that says I have a certain anxiety, and 3 times a day I need to take my anxiety pill. And this employer is not providing you the means of doing that. They're not allowing you access to a water fountain and to your purse or your locker to go take that pill 3 times a day. That seems like it might be some sort of a discrimination against your disability. Doesn't it seem like it might be? Well, think of the animals as that pill. If some doctor is telling you that you have this same anxiety, and instead of taking a pill, you need to have your service animal with you, or in this case, your support animal, emotional support animal with you, that is a way of thinking at it. Because it's not just this crazy liberal notion, it's the concept of a disability that impacts a major life function, and now we need to make a reasonable accommodation. And that reasonable accommodation is the existence of this, in this case, support animal. The service animal, just to remind you, a guide dog is a good example, a signal dog for the hearing impaired. A service dog is a dog who helps do daily tasks and abilities, right? And a support animal is the animal that we described that gives you the emotional support to get through the disability, something that impacts one of these major life functions. Okay.
And you'll notice the pictures to the right of the screen. The first picture shows an actual service animal, and most service animals tend to be dogs. However, there are others. Monkeys have been used by many disabled people. And the question that I never understood why people asked it during seminars is, well, what if they have a miniature horse? Well, you know, I always thought it would be really strange, but I thought if a miniature horse was trained to pull somebody around because they don't have any other means of mobility, then yes, the miniature horse would be a service animal. And lo and behold, miniature horses made the cut. It's right there in the statute.
What's interesting about that is you said trained. The training doesn't need to be done by some professional organization. There are many professional organizations that do this, but the training can in fact even be done by the person with the disability themselves. We're not discriminating based on that. Okay? All right, let's go on to the next slide. What can a landlord ask a prospective tenant? Well, here's what's interesting about this. Remember in the last slide we had talked about support animals and service animals? When it comes to a service animal, there's only 2 permissible questions. 1, are you an individual with a disability? And 2, what is the disability-related task that the animal has been trained to perform? Now, let's look at these 2 questions. Do they have to tell you what disability they have? No. Do they have to tell you, have the animal perform for you to show you a demonstration? No. Okay? Those are, believe it or not, the only 2 questions. What's interesting about this is some are saying that this is actually more questioning than even the support animal, the emotional support animal can, those questions. So let's look at that one for a minute. What can an agent ask if someone shows up? Oh, this is a good one. So what can an agent ask if someone shows up with an animal at an open house? And here is the broker risk management answer. Ready for it? Don't ask. Right? Let them in. Now, if you wanted to have a sign in a house that said no pets allowed, is a pet an emotional support animal? No. So might we be able to live with that? Sure. But when someone walks in with the dog, you know what's great about that? For those of you who noticed, when I said, can we live with that? And I answered it rhetorically, sure. Vicky gave a little cringe. So that's a great broker risk management tip. This is an area you just don't want to tread down. If your client is insistent that you put out a sign that says no pets allowed, well, then you're going to tell them to seek the advice of a qualified California attorney before you do that. But is that theoretically possible? Yes. When someone shows up at the house after having seen that, should you inquire whether or not this is a service animal, a support animal? The answer is don't ask. You're just going to get yourself in a heap of trouble. What can a landlord ask a prospective tenant? So here's what's interesting, and here's what I've been telling agents all the time. I've been telling agents, listen, for your own rentals, you're better off advertising that pets are allowed and charging a fee. Because if you decide to put in your advertisement that no pets are allowed, someone is still going to get their dog in. I promise you. And they're going to get their dog in as an emotional support animal. And you can't, as we'll see in a moment, charge extra deposit, extra rent, extra anything for it. But what can a landlord ask a prospective tenant who shows up with an emotional support or comfort animal? You can ask for a certification of medical or psychiatric specialist that this is a support animal. And that's it. That's it. Now, here's the only good news, is that California now deems these online go in 2 seconds and get a certificate as being the BS that we all knew them to be. So it has to actually be tailored. So an actual physician that you know, for instance, but it doesn't have to necessarily be a physician, okay? If a tenant has an assistance animal, what are the landlord's options? They cannot refuse to rent to that tenant on that basis. It would be no different from refusing to rent to somebody with a disability because of their disability, okay? You cannot require a pet fee, even if other tenants pay one or a larger security deposit or additional rent. Why? Because it's not a pet, right? It's like charging your tenant a fee for having a disability. You can't do that. You cannot impose restrictions on breed or size or weight, and you cannot limit the areas where they can bring this animal. Now,
Dan, can I just interject one comment?
Sure.
You mentioned pet fees, and that's obviously part of this program. The pet fees count towards the total amount of security deposit. And what many landlord attorneys are now recommending is that the security deposit not be broken down into specific areas such as pet fees. Because if you don't specify what part of the security deposit is to go to anything, then you can use all of the security deposit for perhaps the pet damage as just one example. So it may not even be a good idea to have a separate pet fee under those circumstances.
I was thinking of increased rent. Isn't it possible, Vicki, with an actual pet as opposed to a service animal, to offer the place for an additional $100 a month to include a pet?
I would not opine on that since I am not a qualified landlord-tenant attorney. I would recommend that someone consult a local specialist on that.
Very nice. I love it. Okay. You cannot impose those breed restrictions, right? So that's one of the things. You can't say no pit bull, but you can impose and continue to impose behavioral restrictions. So, for instance, if the animal is causing damage, no different from any other animal or tenant causing damage for that matter, the tenant will be liable. All right. Oh, yes. Is this still me, by the way? The websites?
Yeah.
Okay. So this is very interesting. We've been talking quite a bit about the websites lately. One of the things that we're talking about here is disabilities, right? And we're used to accommodations. And so now the question is, what accommodations need to be made for the websites to act for the access of persons with disabilities. And I'll give you two easy examples. Someone who's hearing impaired and someone who's seeing impaired, right? And so is it a reasonable accommodation to require a website to have the ability to change the font size for someone who is seeing impaired, or to be audible for someone who is seeing impaired so that they can click on something that reads it to them, right? And so what's interesting about all of this is there are now some lawyers. Remember some time ago, I think it was about 5 years ago, we had a rash of lawsuits against small businesses up and down. They would go one corridor at another, like West Portal was popular for a little while. And there was one lawyer, and he had 2 or 3 people that worked for him who had disabilities, and they would go into store after store after store, and they would find violations. For instance, the mirror was not at the right height in the bathroom. That was one that was very popular. And they would impose their right against these owners. Some people felt as though the attorney's motivations here were merely financial. And
no. Are you telling me that there are lawyers out there that are motivated solely by greed?
I hate to say it. It's possible.
I'm shocked.
And I don't know if this lawyer was or was not, but some people felt as though this was a shakedown because many of these owners would say, I had absolutely no idea. I'm more than willing to make amends here and make this right. Let's figure out what I need to do. Honestly, I hadn't realized. And that was not even close to being right. That is the model and the example of what we're seeing now, particularly in Florida with real estate agent websites. And so what we're seeing is we're seeing some attorneys who are right now working in Florida, and they're going through real estate attorney websites, and they're saying that they don't have reasonable accommodations. They aren't ADA compliant in that they don't allow for a font size change or for an audible feature. Now, for those of you who are not hosting your own website and are using a service, this is a worthwhile discussion with these services, right? What efforts are made to be ADA compliant to offer these alternatives, right? The larger companies are doing this. The good news is that the attorneys with whom we've been speaking about this, and these are ongoing discussions at NAR and at CAR in our risk management sessions with the attorneys, are not incredibly alarmed right now. And most of these have been either settled with a nasty lawyer that comes back from one of these lawyers, or for amounts of $1,000 and $2,000. Okay, but this is something to consider in the future. NAR and CAR do have this on their radar and will be helping you in the future if this becomes a real issue. Okay.
Okay, great. So just remember that you should be considering being proactive and provide alternatives for people with disabilities. There are vendors online that you can look at to provide guidance if you are using your own rather than your company website. Now, we've talked quite a bit about the fact that service and support animals combined, the subject of assistance animals, are not pets. And many people are very concerned about having pets live in their property or to visit their property. Well, the reason why I cringed when Dan said maybe it's okay to post a sign that says no pets is because I've seen what's happened in the rental ad area. If rental ads specify no pets, then it's sort of like waving the red flag in front of a charging bull. And testers come in. Now, testers, that's the term that is used for the people that Dan was describing in the New York study of steering. Testers are people who can lie about who they are. Testers use scripts in calls, visits, and emails. A few years back, my former employer, who shall not be named, received multiple complaints from an entity called the Housing Equality Law Project, or HELP. They used these scripts to trap real estate agents who had posted online rental ads that said no pets. What was interesting is that in several of the claims, the employing broker didn't actually have a listing. The agent was doing what was referred to as a courtesy listing or a courtesy posting. There's no such thing as courtesy in that arena. If you have a real estate license and you post an ad regarding a rental property or a property for sale, you are acting in your capacity as a real estate professional, and you must comply with all the laws, including the fair housing laws. If you are posting any ads which indicate in any way, shape, or form that no pets are allowed, or you're being asked about pets, there's really only one appropriate response. And this is directly from the people who sued brokers on a routine basis. The only appropriate response is reasonable accommodations will be made for service and support animals. Please feel free to apply. In other words, don't screen out people simply because of an animal. As from my perspective, even though I'm not an expert in landlord-tenant law, landlords face a difficult balancing act because the owner has a legal obligation to keep tenants safe and make reasonable accommodations for their needs. But at the same time, the owner cannot improperly use things such as criminal background checks or refuse to rent to tenants whose disability needs may be in conflict with the needs of existing tenants. Right now, there's a case that's winding its way through the California courts. It involves, of all things, a sorority. And the sorority decided that they could not discriminate against a pledge who had a support animal. The pledge comes in. It turns out that one of the existing members of the sorority has a severe allergic reaction to the presence of the support animal. So there is now this crazy lawsuit, and the question is, okay, who is going to prevail in that situation? Well, I know who's going to not prevail. It's going to be the sorority. The housing screening process has really come under scrutiny in California and elsewhere. If a landlord has a screening process which includes reviewing criminal backgrounds, under California law, housing cannot be denied if the applicant's specific crime is unless the crime is a demonstrable risk to other residents or the property based on objective evidence. A clear example would be someone who was convicted of embezzlement. Well, they stole money from their employer. Does that create a demonstrable risk to other residents or the property? That's really questionable. But what if the person was convicted of arson? In other words, they lived in an apartment complex and they burned it down. That may be a direct basis, except if you're in Oakland.
Right, exactly.
Regulations do not exempt compliance with more protective local laws. And interestingly enough, under the Fair Chance Housing Ordinance, it is illegal in Oakland for a landlord to run criminal background checks at all. They can't do it. And it's my understanding that other cities are looking at this model and are considering adopting that particular law. So what's the possible result of refusing to rent to people simply because of their criminal backgrounds? We don't have a good case in California yet, but New York, again, has come through for us. The Fortune Society was a nonprofit entity that helped people transition from prison into the rest of the world. They tried to get a couple of people a lease in a 916-unit building, but the landlord had a blanket policy prohibiting anyone with a criminal record from living there. The Fortune Society sued the Sandcastle. It was a rather contentious lawsuit. The landlord fought until they were ordered to go to trial, and then suddenly they settled. They settled almost exactly a year ago, And the amount for refusing to rent to two people with criminal records, it was a lot of money. It was $1,187,500. Experts in this field had assured me that if this lawsuit took place in California, the amount would be even higher. Some best rental practices for real estate professionals. I think that Dan and I completely agree on the fact that unless you really specialize in property management of residential property, you should avoid handling leases.
Please, let's just emphasize that. Truly, you want to do your client service, and you want to make sure that your client remains your client. And so your client is someone who bought a house from you some years ago. They now have decided to move into their secondary house in Sonoma, and they want you to rent their house in the city. Okay? Don't do it. The answer is, I am a real estate professional. I specialize in sales, right? I'm more than happy to introduce you to someone in my company who specializes in leases. And I will handhold this whole thing so they understand how important this is to you. I will be part of this, I promise you. But I am not this specialist. And this is no different from going to a neurologist and while you're there asking them to look at your finger because a dog bit your finger. And a dog named, what was that dog's name, honey? Oh, what was that dog's name? Oh, she can't hear me. She's got her earphones on. Anyhow, this dog bit my finger last year, and you can see it's got this big bump in it. And my ring doesn't go on this anymore. And when I went, Biscuit. Yes, she says Biscuit. That was the name of the dog. And when I went to my neurologist, on my way out, I said, neurologist, will you look at this finger and help me figure out what's going on here? And you know what she said? She said, hold on a moment. And she made a phone call. She called her friend who was a hand specialist. And that hand specialist said, I'd be happy to see Mr. Dantastic. Send him to my office next Tuesday, and I'll look at his finger. Did that neurologist provide me with excellent service? Yes, she did. She admitted that this was not her specialty. She sent me to the right person. And on my way out, she even said to me, after you go see Sarah, you're more than welcome to come back to me if you have any questions. I can help interpret if she talks, doctor talk to you. That was fantastic service. You can provide the same service. But if you do it yourself, it is a landmine waiting out there for you to get sued. Please don't do it.
Now, I mentioned earlier the risks of doing courtesy lease listings. Oftentimes, clients will say, well, I just need you to deliver this notice to the tenant.
Oh, God.
This is the landmine that a lot of real estate professionals have had that just, it blows up in your face. If we've learned nothing else from COVID-19, it's that serving notices is now exceedingly dangerous because the rules for how much time you have to give to a tenant keeps changing. The 3-day rule is now a 15-day rule, for example. So the best recommendation that we can give is that unless you specialize in property management of residential property, do not prepare or serve any notices to tenants. Don't give any advice to tenants when representing the current or future owner. Now, the future owner is thrown in there because oftentimes when buyers acquire property with a tenant in place and the contract is subject to the tenant's rights, sometimes the buyer or the buyer's agent are tempted to go talk to the tenant prior to the close of escrow. Those talks may seem rather innocuous, but not in San Francisco. In San Francisco, that can be a basis for suing the buyer and or their agent. Don't talk to the tenant. No matter what the reason is, don't talk to the tenant. The tenants take those communications, they run straight to an attorney, and they allege that you are trying to get them out early. So stay away from the tenants. Finally, if you have a landlord who has questions about who they can and can't rent to, under what standards, what reasonable accommodations must be made, or any questions at all, what I want you to take away today is that there is only one thing that you can say, and my slides are not advancing now for some reason. It'll be the same thing if you ask Dan or me that question. Consult your own qualified local landlord-tenant attorney. The reason this becomes important is now we have federal laws, including the Center for Disease Control, saying who you can and can't evict and under what circumstances. You have state law in California regarding this subject, and you have local laws. This is too complicated. In fact, most of the qualified California real estate attorneys I know will not touch landlord-tenant issues. That's why you need to recommend a local landlord-tenant attorney. So some best listing practices: when it is safe to conduct open houses, keep in mind that putting up the open house sign tells everyone that it is safe for everyone to enter, and you cannot restrict access to anyone.
Of course, right now we can't put up those signs, but when COVID is over, that's the point.
Advise sellers who are worried about dogs, kids, or people with walking devices causing damage during an open house or a visit that their concerns do not enable you as a real estate agent to restrict access. If your sellers have allergies or special needs that cause them to not be able to tolerate having any animals in their homes, first off, they should not have any open houses. Maybe they can do it with appointments, but even then, real estate agents cannot restrict access. You must make reasonable accommodations. So now that we've run through the law, we've told you what the pitfalls are. It's pretty clear fair housing is an extremely important issue. Dan, what is CAR doing about it?
Well, funny you should mention. So some of you may have noticed if since October 1st, you pulled up a car listing agreement, a car lease agreement, or any of the car purchase agreements, that there was a new form bundled with it. And what was that form? That's the Fair Housing and Discrimination Advisory Form. It is a 2-page form that is going to be presented to your clients at the earliest opportunity. That's why it's being bundled with these important forms. And I would suggest giving it to your client at the earliest opportunity. This was released on October 1st, which is very unusual for CAR. We do releases in June and in December and every other day for COVID. But other than that, this is very unusual. The idea here was to put together in just 2 pages the information that you needed. And the first thing that we see here in red is in paragraph 2, it explains what the law is. It shows you the citation to both the state and the federal law so that it's there in one convenient place.
You mean you didn't have to memorize everything we talked about today?
Crazy, no. It's there. California UNRRA Civil Rights Act, that's the California part. Federal Housing Act, FHA, it started with Title 3, right? And it's now up to Title 8. That's the federal act. Let's see the next slide. Here in blue is a little chart. And guess how many little boxes there are in this chart?
22?
22. Because 22 is the combination, as Vicki told us, of the federal and state protected classes. When we talk about a protected class, we talk about these things like race, color, ancestry, national origin, et cetera, et cetera. Now we have a few on there that we've added over the years, like source of income, Vicki discussed, criminal history in certain circumstances, and also what's interesting is any other arbitrary discrimination characteristic. So if you just decided that you don't want to sell to people with blue hair, well, it's probably going to fall under California's arbitrary discrimination characteristic. Let's go on to
would that include like a desire not to rent to people with tattoos or piercings?
I think that's exactly right. Yeah. Okay. Here in green, we see it in paragraph 7. Who does this thing apply to? Well, it applies to you as a realtor, but it also applies to sellers and landlords, real estate licensees, mobile home parks, insurance companies, homeowners associations, government housing, subdividers, property managers, banks and mortgage brokers. So there's a handy dandy list of who this thing applies to. Now, yeah. So let's skip ahead just for a minute. We'll come back to this. We talked about the bundling. Yeah. And this is the one thing I just want to make sure we don't run out of time because we only have 5 more minutes. What we've done here is we've given some examples, and some of the people in the chat have asked about these examples. In here, what the form does in paragraphs 8 and 9, in paragraph 8, it says examples of conduct that may not be motivated by discriminatory intent, but could have a discriminatory effect. Discriminatory effect is very important here because adverse impact is itself just as bad as intentional acts. So when we're talking about these discrimination statutes, that's really an issue. Paragraph 9 are examples of unlawful or improper conduct. And we can talk about a few of those, but I know what you really want to talk about. And Vicky's telling you, read it, and you should read it. It'll take you 2 minutes. But here's what we really want to talk about. An example of something that might get you in trouble. And this is the famous buyer love letter. So you're representing a buyer that you want to put this buyer in the buyer's best light, and they say, hey, can we write a letter? Or maybe you suggest that they write a letter, okay? And so you say, yes, I think we should absolutely do a letter. And by the way, make sure that you put in a photo. I want them to see what a cute couple you are, and include your children, and make sure you write that you have kids and that we're going to follow in your footsteps. I know that you raised your children here. We're going to raise our children here. We're just like you. And by the way, we're so excited because there's a church just down the block, and we're going to go to that church. Definitely not going to go to that synagogue, and certainly not that mosque, but we love that church just down the street. Okay. Now, if that is presented to you as the listing agent, do you have a duty and obligation to present to your client, the seller, all offers that are presented? And yes, that's a rhetorical question. And they attach this thing. Here's the question. Have you done your client a favor or a disfavor as a listing agent presenting this love letter to your client? Hopefully you're thinking now, maybe I've done them a disfavor. Why? Because if they were never presented with information about the race, because there's a photo, the ethnicity, the familial status, the religious preference, etc., it would be very difficult for the other side to say that you took those into consideration and discriminated against us. But when you get 6 offers and they all include these things, it's much easier to claim discrimination. How is it that you as a listing agent could help your client? Well, when you're reviewing this Fair Housing and Discrimination Advisory with your client, you might then be prompted to say to your client, I'd like to add into my instructions regarding offers not to include any love letters or not to include any personal information whatsoever. And I'd like you to authorize me, if someone does, to strip them out and not present them to you. Do you so authorize? Yes, great. Let me confirm that either here in the listing agreement or in an email regarding the same thing. Okay.
So Dan, are you suggesting that brokers do, as an example, a separate set of written instructions whereby the seller either does want to see the support letters or they don't, and that either is a standalone instruction or as an amendment or addendum to the listing agreement, that the seller is the one who makes the decision because it is the seller who is noted in this paragraph as being the primary target for a claim of actual or unconscious bias?
You know what, Vicki? I think the answer to that is yes. And what form would you use? Well, the listing agreement itself could be used. A modification, that's the CAR form. Modification of agreement is the modification to the listing agreement that could be used. And this,
or you could use the amendment form. You could use or you could have a pre-done addendum to the listing agreement form that you take care of at the time. But remember what we said earlier about the bundling. The new FHDA form is bundled in with the listing agreement forms. So, and in fact, if you pull everything up on the CAR platform, first comes the statutory agency disclosure form, and the fair housing form is the very next form. Those two should be considered as precursors, or the two forms you definitely want to use, along with the possible representation of multiple buyers and sellers. You want to use those and give them to the seller or the landlord before they sign the listing agreement.
Excellent. And with that, guess what? It is 2:50 p.m. and we have to say goodbye. But Vicki is pointing to paragraph 9, which tells us what we should do and shouldn't do. And she's pointing to D, making any statement or advertisement that indicates a preference, limitation, or discrimination. So you need to be just as concerned about your own marketing materials. That's where we get into these discussions of a short walk to such and such, right? That's where we get into the discussion of very convenient to the local temple. Terrible idea, right? All right. And I wish we could go on, but we cannot. We promise to be done. We say thank you, thank you, thank you. We were happy to be here.
Bye, everybody.
Bye, everyone.
I don't know if we're still live, Dan, but thank you, Dan. It was nice to you.
Rosario asked about HOAs not allowing pets. Rosario, the HOAs do have to allow service animals. They don't have to allow pets. And that's true for both owners and for tenants, right? So they can't discriminate against an owner versus a tenant and make a different standard, okay? So all of these rules would apply to HOAs.
The most important issue for everyone is you have to stop thinking of assistance animals as being pets.
Right.
Completely separate classification. And I thought the analogy that Dan gave about someone needing to be able to take an anti-anxiety pill, that is exactly the way you have to mentally picture an assistance animal. It is not a pet. It is a completely separate classification. So any rules that apply to pets, forget about it when it comes to assistance animals.
Forget about it.
Forget about it.
All right. Thanks, Vicki. It was awesome.
Take care.
Bye.